Hey everyone, this is the fourth part of the series on how to draft an employment agreement. In today's video, we are going to talk about confidentiality clauses and non-competition clauses. So the first thing that we're going to talk about is confidentiality clause. It is important to include a confidentiality clause in the employment agreement to contractually bind the employee to keep the affairs of the company and the business confidential. So the clause should state something along the lines of the employee shall not during his employment or after termination of the employment without limit in time, that means forever, okay, divulge or communicate to any person confidential information about the business of the company, okay, use for his own purposes or for improper purposes confidential information relating to the company, or through any failure due to negligence, okay, allow the unauthorized disclosure of confidential information. So what is confidential information? Confidential information would be information relating to the organization, the business, the finances, the transactions, or anything related to the affairs of the company. It could relate to any process or inventions of the company, or any process used by the company in the manufacture or in the provision of services. Confidential information also would include information relating to customers and suppliers of the company. You don't want them to use this confidential information after they leave, or try to poach the customers or suppliers. And an important catch-all will be any other information that the company may consider to be of value to the company. You should also include a clause that upon the resignation or firing of the employee, he is contractually required to return all confidential information, which may include notes in writing, memoranda, recordings, anything in soft copy to the company. Next, I'm going to talk about how to draft non-competition clauses. As you are aware, non-competition clauses are generally void and unenforceable. So you should only include a non-compete clause in employment contracts for very senior management, CEO or persons of director level, because these are people who possess very secret information such as trade secrets, supplier customer lists. So what should the non-compete clause address? Firstly, it should state that the employee shall not solicit or entice away other employees when they leave. In other words, they cannot poach their colleagues or ex-colleagues after they leave. You should also include a clause that they shall not employ, okay, any one of their ex-colleagues who is likely to have confidential information or trade secrets belonging to the company. Another clause would be they should not solicit business. That means try to get business from anyone who was dealing with the company before his resignation or firing, because the company may have been in negotiations with customers when this employee was being employed, and you don't want him, after he leaves, to go and poach that customer. The next one would be he will not be directly or indirectly be involved in a competing business. It is very important when drafting non-compete clauses, that means he's not allowed to work in a competing business, that it has to be very, very specific. You cannot just use the words competing business. You have to be very specific. You can watch the video I made on non-competition clauses in the link below. The non-compete clause in the employment agreement should also state that in the event the courts find that any of these clauses are void or unenforceable because of the restrictions go beyond what is reasonable to protect the interests of the company, then the parts that are found to be unreasonable will be deleted and the rest of the clause will stand. So thanks for watching this video on how to draft an employment agreement.